And a common failing we see across a large number of these businesses is a lack of understanding of their obligations in the employment area, especially around an employer's obligations and rights, compliance with fair work laws, workplace disputes, and health and safety, just to name a few. Because of this, we decided as a firm to partner with Employsure in the provision of these services to our clients, as we saw that most businesses just can't afford to have an in-house human resources department, and as such, just leave this area of their business to chance and dealing with issues when they arise in a reactive way, which can be very costly. That said, we have invited David Reid from Employsure to present to you today's topic on running an effective business in line with workplace legislation. So I'll hand you over to David. Thank you, David.
To present this to you. So workplace relations, what's that? I hear you say, but workplace relations is the lifeblood of any business if you think about it. It's how we hire, how we fire, our corporate culture, how we engage our staff, it's performance, KPIs, it's how we go to market, policies and procedures, the things that are unique to us from a discretional point of view as a business owner, but also how that marries in with legislated things from the various government departments and orchestrating that to sync. So that's our area of interest, and as you can see there, workplace fairness and safety. Employsure, we're actually an English company, so between England, Australia and New Zealand, we now assist well over 40,000 businesses as a back office around their workplace relations needs and matters. And for us, it's in Australia, we're particularly speaking about Fair Work, the Fair Work Commission, and also Department of Health and Safety in each state. So firstly, the Fair Work Act and modern awards. So the Fair Work Act of 2009 came into being, and the main driver behind this was to unify the Australian award system and come under the auspice of the government department, which was the Fair Work Australia, should I say, and now the Fair Work Commission. So the Fair Work Act is 900 sections of compliance. There's also the National Employment Standards, which is a cut from the Act, and we'll speak about some of these things. And then there's the modern award system, which now fits under the Fair Work Act. There's 123 of them, I believe, at this point, and some of them are industry-based and some of them are functional-based. And the main thing with businesses is that we identify is a lot of people don't know exactly which award they're meant to be on. And there are industry awards like warehousing or retail, so on and so forth. But then there's functional awards like clerical. Clerical is not an industry, it's a function. So how it works is the industry award will always trump the job-based awards like clerical. So if you have clerical positions in your award, that's the correct pay rate rather than the clerical award per se. So yeah, it's quite tricky to string together, but these awards in principle usually trump the Fair Work Act. So certain awards may say, for example, that under 15 employees you still need to pay redundancy pay. So a lot of trades-based awards like that, like plumbing and carpentry. Whereas if you just look at the Fair Work Act per se, they'll say under 15 staff you don't have to pay any redundancy pay. So there's quite a bit to sync all these different things. And in addition to that, there's the workplace health and safety system. Fair Work also oversees all the justice and equity type things around bullying and discrimination and so on and so forth. So let's have a look at a few of these things. The number one thing here is national employment standards. I just mentioned that in passing. So there's 10 national employment standards. These are rights and entitlements of all employees. This comes as a fact sheet from the government off the Fair Work website. It became law in 2010 that all employees, including casuals, are to receive a signed receipt of this Fair Work fact sheet. So it's really just outlining, as you can see, rights and entitlements that are particular to all employees. And some are unpaid for casuals, yes. And with this signed receipt of that, you can actually demonstrate that my employees do have this fact sheet. It is a requirement. It is a finable requirement. It can run into thousands of dollars if upon audit you haven't got this covered. And really what gets you on the radar of any of these government departments is either a random audit, and ATO, Fair Work and Workplace Health and Safety all do tens of thousands of audits a year. A grievance, like an employee raises a grievance with the Commission. And the third thing with Workplace Health and Safety, should somebody suffer an injury, like a lost time injury. So they're the sorts of things that may put your system under scrutiny. And I've left this screen here so you can read through and see the sorts of things that we can speak about on another day, another meeting or another appointment or another lecture. We can speak about some of these things. But the very important one is right down the bottom there, Fair Work Information Statement. So part of the National Employment Standards is that you have a register that all employees have received this fact sheet. Now let's look at employment type. So a lot of people, beyond identifying the correct award and correct pays, the next thing is usually what's the employment status. So the first two here that we'll look at is permanent full-time, permanent part-time. So they're ongoing positions where we have an ongoing pay scale. That could either be a wages employee or salary employee. There's some differences there which we can speak to at another time. But they do include entitlements, and part-timer would include pro rata entitlements. And basically, these employees may be entitled to redundancy pay. The other one I've got there is casuals. Now, casual is a irregular and not systematic worker. So shifts and rosters and things like that. Some industries, like retail or hospitality, may indeed allow us to have long-term casuals. And in Australia, there's probably millions of full-time workers that are casuals, and technically there's no such thing as a full-time casual if you will. However, industry or certain types of awards do allow this. The main thing is capture it on paper. So some industries have this thing called a casual conversion clause, which, as I've got in brackets there, the offer of permanency may be required, or at least record of that discussion. And then a lot of the time it's about 6 months in after they've worked regularly and systematically. Now, the way to cover yourself against a claim is to actually have a document, a casual contract, which we both sign regularly, either every 6 or 12 months, to demonstrate I've met the requirement of the award system, that permanency may be required, or based on a business need, we can actually still say no. But again, the evidence. So the thing with all these departments is, number one, what's your system? The documentation. Number two, the evidencing along the way. So update of this award, this contract part of that. And number three, what did you do on the day to manage this? And what you do to manage difficulties is just as important as the policy. So you can see there, a casual can still qualify under certain conditions. So if they're a long-term casual, say they've been there for 12 months, a long-term casual can actually file for unfair dismissal, even though they're casual. So the Fair Work Commission sees that their employment wagons to yours, there's some sort of level of expectation of income over this time, and that can actually lead to an unfair dismissal claim if you ramp back your hours or do something untoward on your long-term casual that's regular and systematic. The other thing is adverse action. So adverse action we'll speak about in more fully in a moment. Adverse action is really just speaking to my rights and entitlements. Remember the National Employment Standards? So even though I might not be able to have paid parental leave or paid this or paid that, or paid bereavement leave, I'm still qualified to be able to take it. And if they consider that you've been discriminatory or that I've been bullied or all these other types of claims, anybody, volunteer, casual, visa worker, all can still file for these claims, even if they're a casual on this instance. The other thing, probably the last point, is for permanent part-timers, we are meant to have a part-time agreement where we specify days and hours these days. Some awards allow averaging, but most of it, a general principle is, it's not flexible. It's part of the flexible work request regime where an employee is engaged on a certain, say it's 2 days a week, Monday, Tuesday, between these hours, and that's our contractual agreement. And a lot of people might think, oh yeah, but can you come in Wednesday next week and da 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 da. No. That's automatic overtime if I'm a permanent part-timer. So you can't sort of vary the contractual hours if but by agreement. So on occasion you may need to bring a person in for additional hours, but you would have a variation form that both parties would sign off on. Again, if it's reasonable, if it's an occasion, so overtime wouldn't qualify. So see how you have to have your policies in place, your contracts in place, and your evidencing forms along the way, because a part-timer or a casual may go to Fair Work Commission after time and say, look, I always wanted to be full-time. I was working full-time hours. And if you don't have the evidence to show that you've had the discussion around these engagements, even if you've paid casual loading that, you will still have to back pay their holidays and all this if you don't have the evidence. So very important to get this right, or seek some help to provide it and get it right. Independent contractors, that's the next biggie. The independent contractors, there's lots of toing and froing on this. The rules have changed over the years. What you could do 10 years ago, you can't do now. The biggest one I've seen is me personally, was a contractor down the Gold Coast who was a cleaning company, and they, on legal advice about 10 years ago, said all you really need is ABN and to invoice. But the ATO actually audited them and said, look, you know, when you look at this, it's your clients. They don't have their own clients. You tell them what to do, how to do, when to do. It's your tools and equipment. You're wearing your polo shirts, not their own. You know, they're not really in the business of asset maintenance. They're just solely working for you. So in the building industry and lots of industries, there's been this big term sham contracting. Now, the three departments, the ATO, Work Cover, and Fair Work Commission, all have a slightly different view on what constitutes a contractor. So you can be compliant with one and not the other. And on another day, we can speak through that, what the differences are. But there's some minor dot points there. You know, who bears a warranty? A genuine contractor, like Prudent here, you know, if you engage them to do works on your behalf, well, they have a staff and they employ the staff to deliver the service on your behalf. You don't dictate who they can employ or what they can do. So typically most people are employing individuals, not companies, and indeed dictating to them what they can do, how to do it, so on and so forth. So you can see it becomes very grey, and it's really the commissioner that will decide on the day. But the penalties are huge. As say the one down the Gold Coast, the fine was $150,000 plus 6 years back pay. And the next thing, how I got to know about it, is the Fair Work Commission decided to audit them. So a different regulator was ticked off, obviously. So what if I get it wrong? So the aspects of a fair and safe workplace environment, safety aside, is we do have to be aware of bullying, adverse action, discrimination, unfair dismissal, and breach of employee entitlements. That's what we're talking about a fair play system. So to speak to some of those briefly, so unfair dismissal, most people understand what this is. You know, if your actions were seen as unjust or harsh or unreasonable, as per the first dot point there, you can be sort of taken for unfair dismissal. As I mentioned, even long-term casuals can take you to end an employment contract if they're regular and systematic. So that's that next dot point. What employees have protection? So dismissal must be for a valid reason, for genuine redundancy or a fair process, so on and so forth. There is a sliding scale of paying of notice. So usually when a person is leaving, there'll be maybe redundancy fees. There may be notice period, which you may wish to pay in lieu, and there'll obviously be accrual of annual leave, not sick leave, but annual leave. And it says, what if they resign? So there is a claim in the Fair Work Commission that where an employee can actually quit and say, look, it was untenable to stay. The work conditions weren't practical. You changed my terms of employment. You're putting it upon me, and so on and so forth. So, so you can actually constitute an employee leaving on their own behalf, but still being able to file for an unfair dismissal claim. So yes, waving someone goodbye, thinking, thank the Lord that that's over, may not be the end of the claim. So that's unfair dismissal. It does apply to all types of workers eventually. There is caps. It's capped at 6 months' wages as a claim, and that's the one that we understand the most in the Australian workforce. redundancy, I mentioned that in passing. So a lot of the workers are being made redundant over the years, which really in all terms were actually just moved on because of performance issues. So the Fair Work Commission is very clear on what's performance, what's conduct, what's redundancy. And so when you're moving somebody on, it's usually one of several key reasons. So it could be redundancy, as we've got here. It could be performance. It could be conduct. And that'd be the main reason. So it's identifying which is the correct one to use. So just looking at redundancy, as I mentioned, there's this under 15 rule where under certain circumstances, small business may not have to pay redundancy. But the main thing with working redundancy is the organisational chart has to look different. So it's the organisational chart that's changing before and after. It's not a person or personal thing. So it's not Mary's moving and I'm replacing her. No. To be a true redundancy, we have to change the business structure, not the person. So due to operational requirements, due to other things that we may have to do as marketplace pressures. So the main thing now is that it's a consulted review process. So in the past, we could just sort of select our employees and say, don't come Monday and sorry to see you leave. But under the Fair Work guidelines now, we need to forewarn people if changes are pending. Now, there's risks with that, and it's a way of doing it. So whether that department or group of people or the individual or individuals, they need sort of, they call it consultation in Fair Work terms. So all we have to do is raise that there may be changes afoot, that positions or changes are pending and things may be in jeopardy. We'd just like to bring this to their attention. We sort of back up with something in writing. And with that in mind, they can actually, we give them ability to respond. So some people might put in a flexible work request. What if I work less hours? Or I was thinking of leaving anyway. What about voluntary redundancy? So we have to be able to give people the opportunity to raise these suggestions before we make our final deliberations. So the deliberations have got to be, first in, first off. Yes, that is one, but on its own, it wouldn't be sufficient. We have to look at skilling or a matrix of going forward. So it's like recruiting somebody in reverse. You have to sort of pick the best people to stay because the production line needs less staff because of automation. So Fair Work understand changes are needed, but you have to go through the process. And when the process is adapted or rolled out, you do have to consider redeployment, even if it's a lower level job. You do have to consider this conversation that I've just suggested. So once you've done that, then you can move to phase 2, which is identifying those in the work that are going. So that's the main thing with redundancy. Now, adverse action, this is the other one. This is the big risk for most businesses. It's the most understood claim. Adverse action applies to any worker from day one. It is around our constituted rights. It does include things of discrimination and the like, and there is no cap to this claim. So all the ones of bullying, harassment, or sexual harassment in the workplace, and all these types of things, this is where they sit. And the figures for these claims can be 6 figures, and it's a reverse onus of proof. So all employees are entitled to this fair play. So what you do and how you're evidencing, remember I said dot point 2 or 3, is extremely important. So recently I had a case of a transport company who sacked a guy on ice. You can't have truck drivers on ice. Against the law, against our insurance terms, it's against company policies. So they laid this gentleman off. He went and complained to Fair Work and won $15,000. Now you think, well, how's this so? So they may be good bosses, they may be good people, they may have great policies, but the process, remember, the process is just as important. So with that in mind, did they sit him down? Did they give him right of reply? Did they stand him down? Did they investigate? Did they do all these types of things? If you haven't, they made process errors. And that's what happened on this case. So getting good advice to get these things up to date or to coach you as things pop up is paramount to business success these days, actually. Now, within that, you can see that there is a great financial outcome for this business. So Fair Work aren't adjudicating on your right to dismiss, they're adjudicating on how. So it's really not what the employee's done, it's what we do, and that's the adjudication. So this action, it does extend to pre-employment. You know, I could apply for a job at your company and you may discriminate me based on my age, and I can actually lodge a fair work claim as a non-employee around discrimination. So you can see how it's a Pandora's box, this type of claim. So the rise of the no-fee law firm, they're looking at chinks in your armour, chinks in your process, and things that may be deemed discriminatory. So if I move my worker on who's poor performance and call it redundancy, you can see it's discrimination. Bing bong, you lose straight away. So that's what we're doing, and that's what we're speaking about. Now, bullying and grievances, I mentioned this in passing too. Now, bullying is, you can see the definition up there. It's got to be repeated. It's got to be in the workplace or to do with work. It's got to be unreasonable, and it's got to raise a risk to the person's safety. Now, safety can be mental, emotional, and it can be physical. So things that fit in bullying are not just argy-bargy, but exclusion, not coming to the Friday drinks or not saying hello to a certain person. So that's bullying. So if it happens repeatedly, you may be at risk. Now, an applicant can take their claim direct to the Fair Work Commission. Typically, matters are between employee and employer, but these types of matters are often between staff, and they don't have to go through the company internal process. They can lodge an application, the Fair Work Commission can look and order you to do a certain action. So it's very vital to have a bullying, a grievance process, a performance and conduct policies. Extremely, you're meant to have these things in place. So if that event does happen, you can say, well, we'll come back, we've got a process, we take this seriously, we have an internal mechanism. So it's more likely to be followed should you have one. So that's a great claim. There's a law called Brodie's Law, which is a young lass that took a life some time back in Victoria. And that was due to social media bullying from the workplace mates. So there's case law on this. They take it extremely seriously, as I'm sure you do too. Now, performance and conduct. So there is a difference between performance and conduct. So performance is KPIs and things that pop up as part of the normal rigor of doing your job. And usually there's a working process or during probation you accept somebody. But things may change from performance to conduct quite rapidly. So if you sort of say, as part of I need you to do X, Y, and Z, then if you continue not to do it, you've actually taken my direction. So that then becomes conduct, so misconduct. So it's, you can see a dot point, will versus skills. So will is usually conduct and skills performance. So when we're doing these dismissals, as we said, you know, probationary type things, different things, or they may qualify for dismissal. Yes, during probation we can sort of look at some of these things, but over time, people ask, you know, how quickly can I just give a final written warning? Can I exit in? It really depends on performance, conduct, what's in your policies, what's gross misconduct. But even so, there still needs to be a process for the exit. So that's something to consider when you're considering appropriate levels of action. Workplace health and safety. Now, workplace health and safety is just as something we're just tacking on here, but you are meant to provide safe and fair workplace environments. You do have a duty of care, and your duty of care is to identify risk, do risk assessment. Every business has risk, even white-collar jobs, lifting above shoulders, tripping down the stairs, test and tag, driving vehicles. Every workplace has risk. So you're duty bound to provide a safe work environment. So we have to have a risk assessment. We need to create and train our staff on safe work practices in line with their risk assessment. You have policies like for incident reporting and forms. So yes, you're not a tier one project builder necessarily, but you still have to have your own stance on safety at work. Now, it's not a problem unless it happens. It's 1 in 100, but people have incidents, people have accidents, and these sorts of things do happen. And from time to time, as you know, people crash cars and have lost time injuries and different things that happen from time to time. So again, if someone has a lost time injury or you get audited and you don't have this system in place, they are likely to fine you. And these fines run into tens of thousands of dollars, personal and company fines. all over a simple remedy. So it's easier to fix this than to pay the remedy I'm telling you now. So within that, you may wish to talk to us about a health and safety management system. Our interest is, what is it that, without making it arduous, what is it that we need in place to cover off our bases, to comply with the Act, and just to have these things in place should we need to call upon them. So that's workplace health and safety in a moment or two. But yeah, it is a consideration of business, and it's the only way I can demonstrate I have had this system of consultation where I've considered risk, developed my materials, transferred my risk in part to my staff, if he's meant to wear PPE or they're meant to act in a certain way. So if you think about it, by embracing the system, it's your opportunity to spread the duty, care or risk from me to us. So your staff need to be forewarned or known around safe work practices for them to have any responsibility in your business practice. So there's heaps of claims, and you can see there 66% are 0 to 15. Why? Because we never get around to getting this sort of stuff sorted, and it's not tenable to pay $80,000 HR manager. So what can we do? We can just do the best we can. So for a lot of small businesses, Employsure are an answer to prayer. We do come in, and instead of employing, we do come in with legal guarantees and actually get this stuff sorted fairly and squarely for you, and while maintaining the culture. So every 7 minutes a claim, but it's actually every 3 or 4 now. So ask yourself, do I have this evidence in place? Do I have contracts? Do I have procedures? And all these types of things here, we do actually need to make sure that we've got them in tow and in place. Should we have an incident, investigation, or a grievance raised? So ask yourself those questions. How Employsure helps? Just briefly. As part of the day, I'm happy to take questions, and there'll be a number at the end. But we have a affordable membership where we cover off all your compliance. We get it up to speed. Ongoing, because we understand your terms of reference, we'll cover these types of things so we can give you commercial advice. We do coaching, letters, updates, warning letters, new contracts, policy procedures. So if we can get this house in order for you, the back end, the risky thing, which can actually happen, the person has a right to make a claim, we'll take care of complementary of our safety net. So there's a safety net down the bottom. We have zero excess indemnities with QBE. QBE cover all our clients. Zero excess indemnity if you're taking our advice, our forms, our systems, and representation. So even if you have a good system, good boss, you can still actually fall foul of the law and have claims against you. But you can see here, this is a safety net system where the back end is the guarantee, not billable extra. So it's quite a game changer where we, if you think about it, take a lot of your risk of business on. And just in closing, so that's me, David Reid. That's my phone number and email. Obviously, you can contact me through the office here as well. And more than happy to take calls on this presentation or visit you, or even provide pricing of support. We have different packages and different memberships. So you can see our backers there, Clark Elmore Lawyers, QBE, so on and so forth. So thank you for listening today. It's brought to you by Prudent Partners, and thank you to Joe and the team here. If you do have an inquiry, please contact me directly or through the number that you can see on screen now, and have a good day.